Good day. I'm Chuck Dick with the Program Committee of California Arbitration, better known as CalArb, and we have a wonderful opportunity today to continue our series of interviews called California Conversations. Today, we're going to plunge into a different aspect of the international arbitration arena, and we're going to talk a little bit about institutional providers as distinguished from either advocates or the arbitrator community itself. And I'm delighted to have as our guest today the president of the JAMS organization, Kimberly Taylor. Kim herself is educated as a lawyer, but is functioning as a business person. And I want to spend some time with you today, Kim, talking a little bit about how you made that transition and what the world looks like from your perspective as a business person. But first, I've been told you have a particular skill for and a love of writing, and I wonder how all of that has led you into this particular vocation that you're now pursuing.
Well, thank you, Charles. It's a pleasure to be here today, and I appreciate you giving me the opportunity to talk about JAMS and about the role of the provider in international arbitrations. My pathway to JAMS was a little different than most in that I was a practicing lawyer up in Ventura County for a few years and had the privilege of clerking for then presiding Justice Steve Stone at the Court of Appeal. And I had found my way to that job because I did love writing and I did a lot of that as a young lawyer. And so loved that opportunity to get exposure to a lot of different types of civil and criminal matters and to work as his judicial attorney. And then at the time, he decided to retire from the bench and pursue an ADR career. It coincided with a timing where I was looking to maybe do something a little more broad in my own career besides working as a law clerk. And so I joined JAMS more or less with Steve Stone back in 1999 and did it for the purpose of opening a small office for JAMS to serve Ventura, Santa Barbara, San Luis Obispo counties, and then really fell in love with ADR, and it really matched my own passions and the things I loved about being a lawyer, which focused on solving problems. And I found that being in a role at JAMS on the business side and also at various points in time serving alongside or under the General Counsel's office while I was also running parts of the business just really spoke to me because I loved to be able to take those skills that we all have as lawyers in trying to solve problems to the business world in an environment where our entire mission is to resolve conflict and to get people out of conflict or to ideally prevent conflict from spiraling in the first place. So that's why I'm here, and that was will be almost 24 years ago that I started with the organization, and it's just been really terrific.
But had you explored ADR as a subject matter when you were in law school?
Actually, I did take an elective course, probably one of the first that was offered in California because that's so many years ago, and really loved it. At the time, I was working in a law firm where my focus was supporting the partner who had a white-collar criminal defense practice. So I was doing a lot of criminal work and wrote my paper on ADR in the criminal world, in the criminal defense world. And my professor, Nina Meyerding, who many people on this, watching this probably know and have had good experiences with her. She probably doesn't remember me at all, but she was wondering if that could be a viable paper. And, we talked about plea bargaining and civil compromise and other aspects. So I've definitely had an interest in alternative ways to get people out of conflict and to resolve their problems so that they can get on with their lives.
Well, you indicated that you joined the JAMS organization to start a satellite office with Justice Stone, but you've obviously made quite a progression in your career. Maybe you can track that for us a little bit, how you got to where you are today.
Well, it's I've been very fortunate to sort of ride along with JAM's growth organically over the last 24 years. So when I was working with Justice Stone and a few other neutrals up in Ventura County, there was an opportunity for me to also oversee at the time our Santa Monica office, which is now served in Century City. And then from there also to take over running the operations of our Los Angeles office. And I was also working closely with our then general counsel because the organization was, we were founded in 1979, but there were a lot of regulations that were coming into effect that impacted arbitration, particularly in California. And so I was able to use my legal background to assist JAMS in developing processes and procedures to meet those new regulations, and just to also deal with the growing practice that we were seeing. And so I did that for a few years, and then JAMS made the decision to, we had offices on the East Coast in Chicago and Dallas and other locations, but really wanted to expand our footprint on the Eastern Seaboard. So in 2003, I moved to New York to run that office. And then from there, we grew that region fairly rapidly to add offices in Philadelphia, Atlanta, Miami. We had an office in Boston that we were able to expand. And then since then, we've also opened in Minneapolis and Detroit and St. Louis. And so I just was able to be a part of that growth. And that just naturally led to me then taking, a larger role in overseeing the entire region in all aspects of running an ADR business. So the day-to-day case management, the supporting of our neutrals, making sure our clients were receiving top-notch customer service, and that we were, supporting the neutrals in how they could develop their own practices, and also recruiting neutrals onto the panel. So just overall supporting the growth that we were seeing. And then that led to my being promoted to first Chief Operating Officer for the organization nationally. For a time after that, I was the Chief Legal and Operating Officer. And then today, as of, I guess it was early 2021, that I was made president of the organization, for which I'm very grateful. I love the organization, and I'm very proud to serve it in this capacity.
You mentioned that earlier in your days with JAMS, you were involved in establishing some of the infrastructure. Those are my words, not yours, but I wonder what role your legal training had in helping the organization work its way through whatever the regulatory issues were that you were referencing.
Well, it was invaluable, and for sure. And being able to take, what in some cases were complicated processes, particularly around disclosures and the management of consumer and employment arbitrations, which have unique features, and that require application of our minimum standards of fairness. Just having the ability to discern the new rules, to translate that into the right processes for JAMS, and to then train our people, our case managers and our neutrals in how to properly apply those regulations and rules. I think, being a lawyer was clearly invaluable to me. We do have a lot of lawyers who work for JAMS, not in a neutral capacity, but have come on board to help us with our operations side. So a number of our case managers are former lawyers. We have business managers and other executives in the organization who are former lawyers. We also have a lot of non-lawyers. And I think that sort of diversity of background and different experience that people bring has been equally valuable. So while one doesn't need to be a lawyer to be on the sort of the business end or the support end at JAMS, there are certainly advantages to it.
Well, I want to explore this just a bit more. You talk about the breadth of talent from the legal world that has been brought into the organization in a number of business roles, different business roles. What is it about the lawyer training that has proven to be so useful to jams in these business positions?
I think it helps that for those of us who practice law, we're in courtrooms, taking depositions, we're involved in any type of litigation. It certainly gives us more understanding of what our clients' needs are and the challenges that they're facing in trying to resolve disputes on behalf of their clients. So I do think that that has been very helpful. I also think that others that were practicing law that have come into jams probably have a similar sensibility as I do, which is that it's really nice to be on the side of the legal profession where you're helping people get these things resolved and put behind them so that they can get on with their personal lives or their professional lives, or in an ideal situation, business relationships can be repaired and people can go on to collaborate together. So I think that same thing that attracts me probably is the same thing that attracts others. And I think by and large, the people that come to jams and stay at jams really believe in our mission and our ethics and our values of neutrality and integrity, and wanting to be part of an organization where we're working with top-notch neutrals, really the best of the best around the country. And that's been a privilege. And I think that's probably similar for both the lawyers and non-lawyers who come to work for JAM.
I suspect that many of our listeners would find it natural that an organization like JAMS would have a general counsel and perhaps even an office of a general counsel with more than one lawyer. But my guess is that most of them don't have a clue as to what a general counsel in an institutional provider such as JAMS does, besides, for example, dealing with the disclosure issues you described a minute ago. But could you give us some idea what is the function of the general counsel's office in the instance of JAMS?
I think the function is similar to in many organizations, primarily risk management, and that involves ensuring that we are complying with local and national regulations. That there's an added complexity these past few years with data privacy regulations both in California and elsewhere and internationally. And so we have folks that really focus on ensuring that we are adhering to those regulations. And then we provide guidance for our neutrals who may be dealing with tricky ethical issues or wanting to have better clarity about how to apply our rules to an arbitration. And then, there are challenges sometimes that are made to an arbitrator's continued service on the basis of, some issue that might have come up through disclosures or otherwise. And so we help to navigate that. There's a whole myriad of things that we deal with. And then also trying to ensure that our case managers are constantly receiving, very substantive training on arbitration in particular, because it is more complex than, for example, setting or convening a mediation. There's a lot more steps involved. So our general counsel's office provides a lot of that training and also works very closely with our internal training arm, our JAMS Institute. All of the people that come on board at JAMS, whether they've had years of experience or have just come off the bench or maybe just leaving the practice of law, go through a pretty intensive training program for both mediation and arbitration. And there are other processes that we train on as well. And so our general counsel's office is heavily involved in that. So there's a lot to keep them busy all day long.
Well, yeah, let me shift gears here for a minute, because in some respects, I think you are the archetypical product of the last couple of years as we have moved into this virtual world occasioned by the COVID shutdown. And now, even though we have emerged, all of our lives have changed. You are actually residing in Carlsbad, California, as I understand it, which is not too far away from me here in San Diego, but your primary office is in Irvine, and you're traveling all over the country. How do you find the virtual world that we now have inherited being of value to you, and where do you think that's going to take the business side of an institutional provider like JAMS going forward?
It's a good question, and one that has evolved from the early days of 2020 when we, like the rest of the world, went completely virtual almost overnight. And that was a blessing because we were able to continue to provide services to parties, and disputes were continuing to get resolved. And thanks to a lot of combined efforts and willingness of our neutrals and the clients that we serve to adapt and to learn a new way of doing things, I think that was really great and accelerated a change that many of us in the ADR industry were promoting for quite a long time before the pandemic began, which is using this technology to create efficiencies and cost savings, which is one of the touted benefits of ADR in general. So as the pandemic has evolved and it's changed for us, we have offices all over the country, and some places were more anxious to come back in person sooner and really have that the lawyers and the mediators and arbitrators really prefer to be in person. And then we have other places where we're continuing to do a lot of remote work, and folks are happy with that, and it's working for them. And we'll continue to support that. The other evolution has been and I guess I would apply that sort of to my own professional life, which is it's hybrid. So a lot less travel for me this year than in, say, 2019. And it's been, I think, in some ways great to be able to connect more easily with different people around the country. I can Zoom into a local panel meeting without having to spend a day traveling to and from. So it's allowed me to expand my ability to connect with more people. But I'm in the camp of I really do think there's a lot of value in in-person connections. So when there are opportunities and it's safe to do so, I definitely have been taking advantage of getting back out into the offices. I was in our beautiful Houston office last week, and also visited with our Dallas panel. And then next week, I'm going to spend a little time in St. Louis, which I'm looking forward to. And but then I'm also going to Zoom into a New York meeting. And so I think that there've been challenges to adjust, but overall, I think that it's been really a great opportunity for us to look at ways to leverage the technology that we have, and to sort of stretch ourselves, more broadly. And I think that's true. We hear it from our clients, lawyers who, feel that they're getting, more efficiencies by being able to, work from their home offices or even from their office without having to get on a plane, and getting, more business executives who can maybe pop into a mediation and, maybe saving costs for not having to fly expert witnesses into an arbitration hearing when we can do it effectively, either entirely virtually or hybrid, with some folks in person and some folks Zooming in or using other platforms to connect. So we'll see how it's going to go. I've often asked what this is going to look like for JAMS and other ADR providers in the next few years, and it's hard to say. My best projection is that we're going to settle into a hybrid work environment where people will start to gradually come back in more often, more broadly in person. And once they do, they start to see, oh gosh, I missed this. This is really nice to be together again, but still able to offer the hybrid processes for those folks who can't or prefer not to travel into a hearing.
If my chronology is remembered correctly, you would have been in New York City at or about the time that JAMS really made a serious move into international commercial arbitration. And if that's right, then you've witnessed the JAMS organization's shift into the international arena, along with other providers in this country. I wonder if you could just share with us your observations about how all of that happened and where it's going to take us.
Yeah, so I was in New York at the time JAMS launched its formal international expansion efforts. We had been doing cross-border work for many years, and had relationships with different providers and arbitrators and mediators around the world prior to that. But we opened a London office in 2011. At the time, we were very focused on mediation on the heels of the EU directive on cross-border mediation that had happened around that same time. What we have found is that, and I think to some degree it's a function of people wanting certainty in enforceability of mediated settlement agreements or arbitration awards, that arbitration continues to be the preferred method of dispute resolution for cross-border disputes because of the enforceability mechanism of the New York Convention. But what we've just seen a continued growth in international cross-border arbitration, which makes sense given the maybe slightly impacted by the shutdowns of caused by COVID. But as global trade has increased over the last number of years and more companies are doing business across borders, that I think it's been a natural outcropping of that we see more and more international cross-border arbitration work. Another evolution for us has been the number of our neutrals who do that work. And it was, I'd say 10, 15 years ago, it might've been a handful of folks. And now, a huge percentage of our panel conduct international cross-border hearings every year. And increasingly, we see more and more filings under our JAMS international arbitration rules and our neutrals serving as arbitrators for other panels like the ICC and other organizations in Asia and Europe. And it's just been great to see. Our neutrals handle some of the most complex cases that arise in the world, and I think that they're well adept at resolving these very complicated, challenging cross-border matters. So we, slowly but surely, we've been able to expand the work that we do in that area, and that it's just been great to see.
JAMS, as we know, was really a creature of Southern California practice at its outset, but it's grown domestically. How have you seen this international arbitration practice grow in California specifically?
Well, it's been great to see. Well, it was a few years ago. Everybody who's involved in this organization, understands the importance of SB 766 when it was enacted in 2019, which removed a barrier to practitioners choosing California as a venue for cross-border disputes, because now if a lawyer's admitted to practice in a different state or a different foreign jurisdiction, they are able to practice arbitration in California. So that's been great. That was timely also for us because one of the things we had been hearing from users of arbitration for cross-border matters was the need for different types of technology, the types of things that we've now learned to take for granted in the COVID era, with video conferencing and that, but having translation booths and just different setups for the conduct of those proceedings. And so at around that same time, we opened international arbitration centers with that enhanced technology in New York and in San Francisco and in Los Angeles. So we think that there's a huge market for cross-border work in California. We've got some of the major companies around the world have offices or headquarters here. You've got technology industry, entertainment industry, some of the best lawyers and arbitrators in the world practice in California. So I think it's just ripe for continued growth.
Tell me a little bit about how, as an institutional provider, JAMS gets along, works with, and cooperates with the other institutions around the globe.
Yeah, that's been another, I'd say, really nice product of being thrust into a virtual environment, is that in 2020 in particular, when people couldn't get out of their houses very much, but we're anxious to connect with other people and to continue to learn. We were, fortunate to participate in a number of programs where we collaborated with other ADR institutions on delivering, webinars, seminars, even virtual roundtables, and so that's been great. On the focus on mediation, but I think still of great interest is for more than a decade, JAMS has been involved with the International Mediation Institute. And one of the things I've always valued about sitting on the board and for a time as co-chair of that organization is the ability to collaborate with the other institutional board members of IMI. So with the ICDR, with ICC, with CEDAR in London, and with other, independent neutrals from around the globe. And so we do look for opportunities to collaborate. Obviously, international and domestic ADR providers to a degree compete for business, but I think it's consistent with our values and the desire to grow the profession for everyone and to ensure that we're, staying, at the forefront of thought leadership, that to the extent we can find and develop opportunities for collaboration, we're very much in favor of that.
One of the hallmarks of the internationalization of dispute resolution at JAMS has been the Weinstein Fellowship Program. Could you tell us a little bit about that?
Yeah, that's a terrific program, and that's been, well over a decade, maybe 15 years in the making. We have a foundation that is entirely funded by contributions from our neutrals and our associates. We don't take any outside funding for that as a way to preserve our neutrality. And within a few years of that being launched, we created with the tremendous support of neutral in Northern California, Dan Weinstein, the JAMS Weinstein International Fellows Program. And to date, we've had over 125 individuals from more than 75 countries who come through that program for, it's a pretty thorough vetting process. We receive, lots of applications for a few seats every year. And we bring people in from their home countries and provide them with very intensive training on mediation, arbitration, the business of ADR, how we provide case management support, how people build commercial practices. We also collaborate with other educational institutions to offer instruction on court annexed dispute resolution. And then our fellows are able to have opportunities to shadow skilled mediators and arbitrators in their matter so that they get real hands-on experience and an opportunity to observe. And then they take that back to their home countries and, use what they've learned to either launch, commercial ADR practices or to help their courts become more knowledgeable about the value of alternative dispute resolution and the creation of different programs, or they might take them back to those skills back to other NGOs or other community mediation programs. So it's been great, and it's also then helped us to really continue to build our network of qualified ADR practitioners around the world.
Does the JAMS Foundation support other philanthropic endeavors besides the Weinstein Fellowships?
We do, and since it was founded 20 years ago, we've contributed over $11 million in grants and other providing to support conflict resolution here in the United States, but also internationally.
What is JAMS doing to try and reach down into the more junior levels of the legal profession and bring them on board as an attempt to diversify the international and domestic dispute resolution community?
Yeah, that's trying to diversify the ADR profession has been a longstanding goal of JAMS. It's been challenging at times to increase the ranks of diverse neutrals, whether it's diversity of racial diversity or gender diversity or even age, because traditionally people came up into mediation and arbitration practices either leaving the bench or coming out of major law firms. So the traditional path usually left a pool of folks who would maybe want to pursue a career at JAMS not as diverse as we would like. And so some of the ways that we've been successful in, we've been very intentional about looking for diverse candidates, in all of the communities that we serve, but also making sure that we're providing opportunities for them to get meaningful work. So we, in 2019, brought on a full-time director of diversity outreach so that we can be in places where we can see folks that might not otherwise cross our radar in terms of folks who would be good additions to our panel, and also to educate the bar and users of not only the diverse folks that we do have, but also encouraging them to select those people in their cases. We introduced what we call an inclusion writer into our clause drafting workbook a number of years ago, and it's just a simple paragraph that we encourage folks that are drafting arbitration agreements to include in their contracts, which is just a reminder to consider diversity when appointing an arbitrator on a matter. But beyond that, we launched last year our inaugural Diversity Fellows program. We started small. We had 3 folks, and it was managed out of our New York Resolution Center. And that's been, they had a very intensive experience for a year where they participated in all of our educational programs, and they had the opportunity to shadow neutrals and to potentially work on cases. And I'm pleased that one of those 3 are now a permanent member of our JAMS panel, and it is developing quite a nice business for herself. And we've expanded that Diversity Fellows program now to the next class, and we have I think there's maybe 7 people that are involved in that class, and we just kicked that off. And we're hopeful that by providing these meaningful hands-on opportunities to work on cases, to meet our neutrals who are also interested in mentoring and helping the next generation, whether it's younger neutrals or neutrals from potentially a different background, to come into the profession and to ensure that they have meaningful support and aren't just coming in and getting a training and then leaving, but that we're doing all that we can to try to help them build practices and so that we can better serve the communities that we're in. We also started using, and this sort of happened organically over the years, with particularly neutrals who have really busy practices. And this is also not uncommon in the international arbitration world to use in that world a tribunal secretary, but then in the domestic world a law clerk, much as they might have used a clerk at the court if they were a judge, or an associate at a law firm. And with the parties' consent, these clerks can be very helpful in doing some of the work that at a maybe lesser rate than the arbitrator would charge, just to create more efficiency and cost savings. And that's also proving to be a good career path for some of those folks who come in potentially as clerks, work very closely with our neutrals on the matters that they're working on, get introduced to the parties and the clients, and then are able to use that as a launch pad for their own careers. So we're trying hard. It's a huge priority for us to do whatever we can to diversify the profession and make sure that the cadre of neutrals better reflects the communities that we serve. So it's an ongoing effort, but excited about what's going on.
My guess, Kim, is that as the president and principal operating officer of a company like JAMS or its companions within this industry, you must spend a little bit of time doing strategic planning and thinking about the future. And I can't resist asking you, where do you see this profession going, and how is dispute resolution going to be evolving here in the immediate future as you see it?
Well, I wish I had a crystal ball, but you're right. I do spend a lot of time along with my other colleagues on our senior management team thinking about the future and making sure that we're positioning JAMS well to be of service in emerging practice areas or in the delivery of the service that we provide. It's one of the things that distinguishes JAMS from other international providers is that we are technically a for-profit organization where many others are not-for-profit, but we don't run the organization solely for profit. We really do what we do to provide high-quality dispute resolution. We put most of the money that we make back into the business to, support the advances in technology in our facilities and, making sure that we're providing the best service. But it is still important, I think, for any organization to, be mindful of growth because costs increase year over year, and we have, good people that we want to ensure that are, having a good career at JAMS and that we're providing the best possible support to our neutrals. So we do look for other areas that might be expanding. I think that the pandemic showed a lot of people the value of alternatives to the court. Court provides an amazing and important function, but 2021 was one of the busiest years we've ever had as an organization. And it's probably true for a lot of practitioners. Because folks couldn't get into courthouses and I think saw the value. So I think that's going to continue to be a trend that we're going to see more cases using alternative dispute resolution globally. I also have a desire and a hope that more and more businesses will see the value of employing conflict resolution techniques earlier in the process, either within institutions before a conflict arises. We have a program that we launched earlier this year that we call Pathways, and it is designed to provide conflict resolution training to individuals within large organizations who might not even have ever heard of mediation or arbitration. That's just not something that they've had to deal with, and we're finding a lot of interest in that. And I feel, I guess, going back to what I said earlier, that I just love what we can do in our profession to help people out of conflict, but even better if we can prevent that conflict from spiraling to begin with. And I think that's going to continue to grow.
Well, Kimberly Taylor, this has been a delightful conversation this morning. You've been extremely articulate in describing not only your organization, but more generally speaking, where dispute resolution has come from, where it is, and perhaps now where it may be going. I want to thank you on behalf of CalArb for taking your time to share these observations with us. It's been a treat. I'm sure that our viewers will enjoy knowing a little bit more about you, but more broadly about institutional providers within this sector. And so with our expression of gratitude, I close this out by saying thank you again so very much for being with us.
Thank you very much for the opportunity, and I look forward, hopefully in the coming year, to meeting other CalArb members as we start to get back in person more often. So thank you.
Sounds like a plan. Thanks, Kim.
Great.